The next case to come before the court is State of Ohio v. Mahdi. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I'll try to keep track of the time. The arguments are being recorded, so please stay behind the podium and keep your voices up. You should not use the names of victims or children or minors should that be relevant to your argument. You can refer to those folks by general terms. The judges have read your briefs, and we're ready to proceed when you are, and I would just ask appellant, would you like to reserve time for rebuttal?
Yes, I'd like to reserve 4 minutes of my time for rebuttal, Your Honor.
Very well, then we will proceed when you are ready.
Thank you. May it please the court, my name is Russ Benson. I'm here on behalf of Mr. Mahdi. Now, the first issue I'm not going to deal with extensively. That's with regard to WM's testimony. I think that's adequately covered by the briefs, and what you have to decide is whether 15 months is soon after, and whether the state showed that the testimony is reliable. And as I indicated, I think the briefs adequately discuss that. If you have any questions about it, of course, I'm perfectly happy to answer them. But I wanted to concentrate on the second and third issues, and that is the Dollard testimony, the Dollard hearing that didn't take place, the Dollard requirements, and specifically with regard to the state's expert witness, Adam Mosher. I would indicate that he was never qualified as an expert. They got into all of his qualifications. There didn't come a time when they asked the court to qualify him as an expert, but he most certainly was. In fact, they asked him whether his testimony was to a reasonable scientific certainty, which is indicative of expert requirement for expert testimony. So there's no question he was an expert. The question is, should he have been permitted to present his testimony? And I think what you have to look at first is what was his testimony as to the procedure that he employed in identifying Mr. Mahdi as being near the scene of the incident. His testimony was that he developed a cyber profile, and specifically, this is found on page 6 of the state's brief, quotes him, "The cyber profile is based on an individual's email address, phone number, social media accounts, or other electronic app accounts, and CyberCheck is capable of locating an individual's cyber profile when it connects or attempts to connect to wireless internet sources." And that's as far as the explanation went. There was no testimony regarding how he did that. There was certainly no testimony regarding how he put Mr. Mahdi in there, because he did not, although he had the email and account and various media accounts and the phone number for Mr. Bush. How he put Mr. Mahdi in association with Mr. Bush is a complete mystery, because he never indicated that he got any email, any phone numbers, or any media accounts for Mr. Mahdi. You look like you want to ask me a question.
I do. With CyberCheck in Summit County, obviously it's the police that employ an independent contractor. But
yes.
How is this different than in federal court, where they have the FBI with a cyber expert making testimony?
Well, first of all, I don't know any particular case where the FBI has a cyber expert of this nature.
Well, they have a cyber department, and they have people who have certain expertise in cyber investigation.
Oh, absolutely. But what they do is they indicate, and I haven't had a trial involving that. I do practice in federal court, and I can't remember anybody talking about a trial like that. They have experts come in and testify as to the extraction of cell phone data. They have experts coming in and testifying as to how they got intercepted wire communications. I have not seen or heard of anything like what CyberCheck does in this case, developing a cyber profile. And again, regardless of how they developed it for Mr. Bush, which is not all clear, they didn't. How they developed one for Mr. Mahdi, when they were given no information with regard to him, is a complete mystery. And how they tied him in with Mr. Bush is again a complete mystery. I mean, it's just, if you look at the requirements of Rule 7.
Secondly, I'm sorry to interrupt you.
Oh.
There was no request for a Daubert hearing.
There was.
And no objection.
That is correct, and
So
under
that-
the plain error standard, that gives me problems, and I'm more than happy to concede that, okay? But under ineffective assistance of counsel, which has a much lower standard, undermining confidence in the outcome, his failure to request a Daubert hearing is what I'm contending. And if a Daubert hearing was required because the evidence would not have come in, if it was not admissible under Daubert, then there's no question that it's ineffective assistance of counsel not to request one. By the way, I'm sorry, I'm a little out of breath. I got lost in your garage and I was running around all over the place. So at any rate, if you look at the requirements of Evidence Rule 702, the very first requirement under subsection C, which says that the testimony has to be reliable, and it's reliable only if all of the following apply. And the very first one is the theory upon which the procedure, test, or experiment is based is objectively verifiable or is validly derived from widely accepted knowledge, facts, or principles. There's none of that here. There is nothing to indicate how he derived this. There is no objective criteria indicating how he derived this, how he created this cyber profile. There's no widely accepted knowledge, facts, or principles in this. So it fails the first test under 702.
Yeah, but we don't know that because there wasn't a Daubert.
Well, we do know that because there was testimony. There was testimony, and there was no testimony that indicated, in fact, this is proprietary software. This is not something that he goes out and shares with everybody. He charges the Akron Police Department $25,000 a year to do it. This isn't a widely accepted, he doesn't come in and say, okay, for example, blood splatter evidence. There's widely accepted principles with regard to blood splatter evidence. But one of the problems with this is there's so much junk science out there, okay? We know that tooth mark analysis is bogus. We know that hair analysis is bogus. There's questions about fingerprint evidence when they pick up a guy in Washington, a lawyer in Washington, because of a train blowing up in Spain, and they thought his fingerprint was on it. A guy went to was executed in Texas because of faulty arson evidence. So you've got all this bogus evidence floating out here, and here comes a guy and says, hey, listen, I created a cyber profile so I can spot where these guys are. And he doesn't tell you how he does it. There's no explanation of how he does it. There's no widely accepted principles or facts or theories that would allow that.
I have another question. There is cell tower information here.
Yes, there
Which
is.
does indicate location.
Well,
So could it be argued that this is cumulative?
not really, because the cell phone tower, I think and I don't think it was an expert, because you don't need expert testimony for cell phone tower.
That depends on the district.
Well, that's true. Let's put it this way, I haven't found a case where the testimony was thrown out because the guy wasn't an expert. And believe me, I've researched that to death. But be that as it may, the person who testified in this case admitted that it covered an area of about 50,000 people. So how particular that was. I mean, when you got this guy coming in with this, oh, we did this and we did this, and cloaks it in scientific gobbledygook and says, yeah, we can pinpoint him to within 25 feet or 25 yards of where the shooting took place, at the time the shooting took place. I think that's very damning evidence for the state if it doesn't go challenged. And it went unchallenged in this case. And then when you look further at the Daubert requirements, that's just Evidence Rule 702. If you look at the Daubert requirements, where's the evidence of peer review? There is none. Where's the evidence of publications? There is none.
But peer review is just a factor to look at.
It's just a factor to look at, but when you look at the various factors and he doesn't meet any of them, what does that tell you? Okay? Widespread acceptance can be an important factor. Okay? What's the widespread acceptance? He says there is. Okay? There's no indication that anybody uses this. I mean, it's one thing if he gets up there and says, yes, police department, there's several companies doing this sort of thing, and so forth. He doesn't do any of that. The only rate of error that we know about is what he testifies to, and that only goes back 2 years. And the first one is, can the technique or theory be tested? And we don't know anything about that. There's been no evidence of it. So it's clear that this evidence would not be admissible. This testimony Now, maybe there's more. Maybe if there was a Daubert hearing, he could have been required to produce more. I don't think it would have done any good because, I mean, the state put him on the witness stand. The state certainly could have enhanced his, the weight of his testimony by going into detail about the factors and whether there was widespread acceptance and those things. But it didn't, and I'm not sure, given his testimony, that it could have. So if a Daubert hearing was required, and I believe it was, and the hearing would have disqualified his testimony, and I believe it would have, then you got error. It was error for either error for the court to admit it without a Daubert hearing, or error for the attorney not to object to it. And I tend to think that the latter is a more compelling case, in all honesty. I think you have problems with plain error, but you certainly don't under ineffective assistance of counsel. That's been the law for 30-some years for an attorney not to realize that he could do that. I don't think that there's any question of deficient performance. This isn't a situation where it's a reasonable trial strategy. There's nothing to be gained by not having a Daubert hearing on this, because the evidence came in. And does it undermine confidence in the outcome? Now, I know Detective Stanner tells you at the end of the trial, or tells the prosecutor near the end of the trial, that the evidence is overwhelming, but previously testified that prior to WM coming forward, they didn't have enough to get an arrest warrant, let alone prove Mr. Mahdi's guilt beyond a reasonable doubt. So is it harmless? No, I don't think so. You have two real bits of testimony in this case that are harmful to Mr. Mahdi. The first is WM's testimony, obviously, and that goes back to the first assignment of error, and I don't think that should have come in for the reasons that I explained there. The second is...
And you are moving into your rebuttal time.
What's that?
You are moving into your rebuttal time. I'm just going to let you know.
Oh, okay. Yeah, you don't need, okay. That's interesting. I haven't seen one of those. You guys go high tech for this sort of thing. I think the 8th District of Evans bailiffs say you've got 2 minutes left. So, okay, if there aren't any further questions, I'll rest at this point and save the remaining time for my rebuttal. Thank you so much.
Very well.
Good morning. My name is Rick Raley. I'm appearing on behalf of Summit County Prosecutor Sherry Beth Walsh in the state of Ohio in this matter. This court should overrule the assignments of error, affirm Mr. Mahdi's convictions, and I'll likewise limit my presentation to the second and third assignment of error, unless you have questions that lead us other locations of this argument. The second assignment of error and these arguments that we've heard from the appellant are speculative completely, and they are based on belief of what they think that the quality of the cyber check evidence is. None of that is in the record. All we know in the record is that there's been 2,748 asks of this program. It has a 99% accuracy rate. There are 472 missing persons cases. There's a 100% accuracy rate in those cases. We know about Mr. Moser's credentials, his certifications. We know about the process of deconfliction and what he uses to put together the responses to the asks. We have the report in the record, and those explain how they place the defendant where they at the murder scene near the time of the murder. On top of that, we do have testimony that this is accepted in this field. We have testimony that it is within the reasonable degree of scientific certainty that these conclusions were made. Now, there was cross-examination on those points. Those were all raised to the jury to consider. They considered that cross-examination and decided based on all the evidence record that the defendant was guilty. And I do want to highlight, again, this is in the brief, what the evidence is. There were FaceTime calls from the defendant to people in the barbershop at the time of the murder. There's a shell casing that has his mother's DNA on it. There's cell tower records that place him in the vicinity of the murder. He had a motive to kill the victim. He has a height and hair that matches eyewitness profiles. And once he is arrested, he lies to the police. Based on all of that, there's plenty of evidence for this trial, for this jury to have found the defendant guilty, even without considering cyber check. And I would push back on this idea that the ineffective assistance standard is somehow a lighter standard than plain error. It's an extremely high standard, as you've seen in plenty of briefs that have been briefed to you. it could have been very well a reasonable trial tactic to look through this, to hear that testimony and say, I don't have the grounds to ask for a novel hearing of this. They're going to beat that. I'm going to go some other path, which they did. And the prejudice prong again. All this other evidence, clearly, it's not effective on this particular prong. Judge, you have a question?
No, just an expressive human.
Okay. So with that, if there are not questions, I would ask you to affirm the trial court's judgment. I think that all these arguments are speculative at best. If there are concerns that are outside of the record, they have to be raised in post-conviction relief. And with that, I ask you to affirm.
Thank you.
Thank you.
What is in the record? You have a statement that he created a cyber profile. You don't have any testimony about how he did that. The only testimony as to its accuracy is his own testimony. You don't have any evidence of, and he goes into detail in his credentials, and if there was an acknowledgement or evidence that this was widely accepted in the scientific community, if it had been peer-reviewed, if it did rest on a test or a procedure that is objectively verifiable or is validly derived from widely accepted knowledges or facts or principles, it'd be in there.
Counsel, can you go back and talk a little bit more about why all of that other evidence, why is this the critical piece?
Well-
Because we have as prosecution point, or the state points out, the cell phone report, the shell casings, the mom's DNA, cell tower records, motive, physical description that matches, and
Well, and I'll respond to that by way of responding to the state's argument that ineffective assistance of counsel is a high standard. It's not. It's undermining confidence in the outcome. That's all that is required. It casts doubt on the jury's verdict. Plain error, by contrast, as the Supreme Court recently stated over the past year, can only be used in exceptional cases involving the manifest injustice. Now, I would think that a guy serving 28 to life for something that he may not have done is a manifest injustice, but it's clear that the standard for ineffective assistance is much lower than that. So now, to direct myself to your question after that detour, yeah, there's other evidence, but like I said, the cell phone tower evidence could apply to 50,000 people. Okay, the DNA on the mother's DNA on the casings, and is that weird or what? I don't know this. She had 3 other sons, so maybe one of them did it. I don't know. But all I do know is that Stanner testifies. Detective Stanner, who was in charge of this investigation, testifies that up until the point where WM came forward, after they had the shell casings, after they had all this other evidence, after they had people saying, well, he looked something like the guy that did it, he says they don't have enough for an arrest warrant, let alone to convict him beyond a reasonable doubt. So I think that, certainly that's evidence. Is it overwhelming evidence? And keep in mind that the state bears the burden here of showing that the evidence is so overwhelming that any error is not prejudicial. And I don't think they can do that in this case. You don't have anybody saying, yeah, that's him, except WM 15 months after the crime. You don't have any forensic evidence other than the mother's DNA on shell casings. What you have is you have WM and you have Adam Mosher. They're both putting him on the seat. And if that evidence goes, then they don't have a case. They could have brought a case without that. And as far as, addressing the situation with he could have decided, made a reasonable trial strategy that
we're going to have to ask you to wrap up.
Okay, I will wrap up right now.
Sure.
Cross-examination, yeah, he could have done things on cross-examination, but Daubert doesn't speak to the weight of the evidence. It speaks to the admissibility of the evidence. If the evidence isn't admissible, it doesn't go to the jury. There's nothing for them to weigh. Thank you very much.
Thank you very much. Thank you both for your presentations. The court will take it under advisement and issue a decision in due both be notified on the day that the decision is released by the clerk of court, and you'll get a mailed copy to you. The opinion